Welcome to Protecting Your Legacy with Estate Planning.
Hello, everyone, and welcome back to Protecting Your Legacy with Estate Planning with Adam Grant. Adam is the founding attorney of Stonewood Law Group PC in Encino, California. He helps families across Los Angeles, Orange, Riverside, Ventura, and San Bernardino counties build clear, comprehensive estate plans that protect what matters and help avoid probate. I'm Sean O'Connor, and today Adam and I are talking about small estate affidavits. Adam will explain what they are, when they can be used, and how they fit into the bigger picture of estate planning. Adam, how are you? Good to see you.
I'm good. Good to see you, Sean. Thank you.
Let's get right into it. To start with, what is a small estate affidavit in California, and what exactly does it allow a family to do?
Yeah, so a small estate affidavit is a process and tool that allows families to avoid probate while getting a distribution or an asset transferred over to them via legal means. So the ideal number to consider here is $184,500. So why do we say that amount? That's the statutory amount set by law here in California. It changes by state. They have different rules in other states, but at least in California, if you have anything below that amount, you can do what's called a small estate affidavit. It's a tool to avoid the formal probate process, whereby the next of kin or the one entitled to that asset can fill out an affidavit after waiting 40 days, have it notarized, brought to the institution, and the institution can then release that asset, provided it's under that statutory amount, to the beneficiary, the person who it's supposed to go to, without liability.
I see. You mentioned the dollar amount for the state. Are there other factors that have to be true for an estate to qualify for this kind of a thing, especially when it comes to value limits or how certain assets are counted?
Yeah. So what they're looking at, the court, is the gross value of the property, the asset, the estate. And if it's under $184,500, that's where the court will defer to an individual who notarizes and acknowledges under oath that they are entitled to that asset, the bank then releasing that asset. The other real qualification here to really keep in mind for people trying to go this route is the 40-day waiting period. Clients often try to do this prematurely, and it does not allow the banks to accept those small estate affidavits. So waiting the requisite time period, ensuring that the gross amount is under the $184,500, and then you can go to the institution, either request a small estate affidavit from that institution, or you can get a standard form from a lawyer or somewhere online, if you find it online, and submit that to the institution. They'll accept that, and they will be liability free when they release that distribution or that asset to the beneficiary.
So when you're looking at someone's estate, what types of assets can actually be handled this way? And, obviously we're going to get into a dollar value here, but which ones tend to fall outside of it?
Perfect question. The big outlier is real property here in California. So the amounts that qualify for a small estate affidavit with real property does change. It's around $67,000 now. But you really want to look at the types of vehicles that you use this small estate affidavit are very general. You can apply it towards a vehicle. You can apply it towards a bank account or assets, stocks, non-cash accounts. When it comes to motor vehicles, it makes it easy. The thing is, when you come to real property really is the differentiating factor here. Unless it's below that statutory amount, almost all real property does have to go through a formal probate process. And the outlier here are really anything that's already tied up. So if it's already in a trust, if it's already got a POD or TOD, what those are means payable on death or transfer on death. So depending on if it's a cash account or a non-cash account, there may be a beneficiary already named on that account, so a joint tenancy account, in which case it already goes to that second named party.
I see. And that sort of thing, the TOD or what was the other one?
POD.
That takes precedence, so to speak, over.
Absolutely. So the designations made with the bank or the institution will always govern. There may be small outliers where you can appeal to a court to undo some of that. But in most realities, we typically tell clients one of the cheaper, more effective ways to do some of this estate planning is by naming these beneficiaries. They're just things to be conscientious of when you do that. One example here would be having a joint tenancy property with someone who is not a spouse. So there may be, when that person passes away and the interest then passes to the other joint tenant, there may be gift or transfer taxes, and there may be liabilities or other things to be aware of.
Speaking of real life, circumstances, real life factors, what does someone actually have to put together, and how do they go about using it?
So, in order to implement this tool, you would talk or at least locate the institution first. You talk to them, find out what asset is available under that beneficiary's name or
Hmm.
under the decedent's name. You would then ask if that amount is under the $184,500, in which case, if it is, you can go this route, the small estate affidavit, after you wait the 40-day period. If the bank comes back and says it's in joint tenancy or it's in trust, there's not much you can do. It's likely going to fall to the designation left by the decedent. But if it's not, and it's perhaps a probatable asset, it's above 184,500, this tool is not available to you. Or if it's real property, more likely than not here in California, this tool is not going to be available. This small estate affidavit is really for assets that are of small value that can easily be acquired and obtained from the bank without having to bother the court.
I see. I see. Um, I'm imagining that people get tripped up or surprised by, as they're trying to, use this tool. In your experience, are there situations that come up that are pretty common, or maybe people think they qualify but don't? You mentioned a couple of things there in terms of just given the price of real estate in California, it's going to be rare that could be under the threshold.
Yeah, very much so. And there's so many iterations with clients having troubles with banks, whether there's a second trust the bank says that addresses the asset, whether the decedent has a death certificate that can be provided by the beneficiary, whether there's a will. So there's a lot of things that the institution may require. You can ask them. I always say it's best practice to reach out to that institution, having found that asset, making sure it's under the requisite amount, what their form or process is. So at banks, you'll often talk to a teller or a front-facing person, but there are departments that specialize in this, and you can ask for those departments, be connected with them, and go through their process for completing their affidavit, which you'll then have to have notarized with any will or backup documents showing that you are next of kin or a beneficiary to that asset. And if they feel comfortable with the paperwork and the 40-day period has elapsed, they will release that asset to the named beneficiary.
Got it. That sounds straightforward enough. Um, well, I suppose I was going to say banks, but I mean any financial institution. I'm guessing their in-house requirements differ, or is this pretty tightly regulated and uniform?
So it's not very uniform, although it can be uniform. There is a uniform wind down form that you can submit, a uniform small estate affidavit that's available online, that's available
Mhm.
to attorneys. They can complete just a statutory small estate affidavit. The other way to do it is, again, reaching out to that institution
Yeah.
and just saying, do you have a form that you would like us to use? That always kind of avoids any pushback. Although if you meet the statutory requirements of what's supposed to be in the small estate affidavit, they are supposed to accept it.
Understood. Understood. You mentioned earlier a joint tenancy scenario. How should people think about joint tenancy accounts in this context? When do they help simplify things, and when do they end up creating potential issues?
So joint tenancy is a great tool, especially if it's a family member or a spouse, even better,
Hmm.
where that interest can then go to the person afterward. If you don't have a joint tenant on an account, so you're the only named party, it's your account, it should either be in a trust. You should update it so that a beneficiary is named, and that way it goes to the person you want it going to. Although what happens is that person who you've named may pass away before you. You may want to go into a bunch of people in a bunch of different ways. So that's where you have some flexibility by building a trust and having that account named as a beneficiary or put into the trust. And then it flows through the trust. You have more flexibility in how that asset is used and distributed. Absent that, joint tenancy is a backstop. It's an easy route, especially if you're a spouse, to transfer property and have it pass after death. But if you don't have a joint tenancy designation, a small estate affidavit is the tool that you can use to keep it out of a probate, which is a very long, costly, arduous process, something I try to keep clients out of as part of my practice, focusing on avoidance of probate at all costs.
Yeah, yeah, I hear that a lot, and I know. I mean, you just alluded to it. I mean, this is this is your expertise, and you're working with these kinds of issues every day, and they're all unique. I like to say they're all similar, but they're all different as well. And I'm curious if you can share an example of where this joint tenancy or other issue worked great for a family, or where someone expected it to work but ran into problems. Are there any scenarios that you could share that would also serve uh, as a lesson for anybody listening to be like, oh, watch out for this?
Yeah, no, I think actually a perfect example would be a case I'm working on now, where one of the trustees of a trust is looking to another named subsequent trustee. So they are not the current trustee, they are the next named trustee who is overly asserting their authority now, when the current trustee is trying to exert his authority and maintain the distributions for the beneficiaries. With trying to ascertain what assets fall under the trust, there are certain accounts the other subsequent trustee controlled that named him either as a beneficiary on that account, so a joint tenancy account, or whether it wasn't a joint tenancy account and it was a trust account. The difference makes all the world. So if we have it as a trust account, the trustee is able to manage that account. If it's in joint tenancy, there's no control over that asset, and whoever's named on the account will most likely get that asset. There are other ways and mechanisms that you can approach this, but joint tenancy is a very good tool if the circumstances are correct. So a spouse is usually the best person to include. Absent having someone you trust as a joint tenant, just be aware that that property is automatically going to go to the other person, with tax implications and anything else that might go along with it.
I see. I know there's probably uh, degree of strategy and involved in these cases, and also people have different goals in terms of what they want to accomplish or see happen after their death. If someone is out there, they're planning ahead, which you love that, right? Uh, how do you approach the decision between, say, relying on tools like this versus putting a full trust in place? So there are pros and cons. Are there certain like hard, fast rules that you follow?
Very much so. Doing this asset by asset is what I call patchwork. So, yes, to a degree, it does effectuate your wishes, but there are contingencies you're not accounting for. So, if you have a joint tenant or another person named on your account and that person predeceases you, where does that money go? If you want it going to several of your children, well, you're not going to put several of your children as the beneficiary. So, a trust gives you the access to let it go to the people you want it going to in the stages you want to go into them. So if 30, 35, 40, that's how you want to distribute it at different percentages, you have that agency and control through a trust. If you go through the joint tenancy route, asset by asset, you may miss an asset, which means it has to go through probate. So effectively, the process that you've gone down, it's not really that valuable because you're going to have to go through probate. Perhaps you've forgotten to put property, real property or a car in your name. Well, having things transferred from your name to the trust is a little bit of a difficult maneuver. But if you have things in your trust, you make things very simple for your beneficiaries to then accept those from the trustee when it comes time and pursuant to your wishes, versus letting a bank determine who that next person is, and perhaps the next person has predeceased you. There's not a lot of instruction for the bank. The trust is the foolproof way to avoid a lot of the pitfalls that come with just putting someone on the account. It accounts for things that aren't specifically put in the trust if they're assigned to the trust and their general assignments. But you want to structure your estate so that all your assets are lined up to go to your loved ones with as little tax incursion as possible. And the best way to do that is, of course, through a trust. Unless you just have one or two accounts and you want to make sure those smoothly and easily go to the people you love, just putting them on the account may be the best and easiest route for you.
Got it. We just have a couple minutes left, and I just want to surface this because you mentioned scenarios whereby people's situation change. There's someone, a designee dies before the person, or the new car is acquired, or like life happens, right?
Life happens.
It sounds like you need to be, you got to update this stuff, right?
That's so extremely important. I could not suggest enough that you revisit the designations on your accounts if that's the way you're doing this planning. Otherwise, to make sure things are all in your trust and amply taken care of. I'll give you an example here. So one example, something I'm working on now, I have a client who is trying to probate his father's estate. And most of his father's will and wishes are clear that the accounts and that his assets go to his son. There's one account, however, that still names his estranged sister, who he didn't speak with for the last 30 years of his life, on one of the accounts. It's a big bank account. It has a few $100,000 in it, and the beneficiary would really like to see that that asset goes to him pursuant to his father's wishes. His father made clear the sister that he had no relationship with. He did not like, he did not want her in his life, and he never updated his beneficiary designation. So now there's a court process whereby you try to undo this. You know his will, you know his intent. He made very clear that these types of accounts and his other assets were to go to his son. The thing is, he never realized his old account still had his sister with her named as the beneficiary on the account. So that's a very important reason and example where you can see how vital it is to keep these beneficiaries and designations at your institutions updated.
Yeah, that's good. And I'm assuming, obviously, if I'm working with an attorney such as yourself, you're going to be checking in I'm sure like every year or two, like, oh, anything I need to know, anything we need to update. Yeah.
Very much so. We give clients very sincere instructions, and we ask them to circle back with us when life events change, when new accounts or new companies are acquired, big life events that trigger something like reevaluating your designations on your accounts and perhaps your trust.
Yeah. Well, that's great. Adam, we're out of time, but as always, great to talk to you, and I look forward to future conversations.
Thank you for having me.
You bet. Thanks for listening to today's episode of Protecting Your Legacy with Estate Planning. If you'd like help structuring your assets or understanding whether a small estate affidavit could apply to your situation, visit the website stonewoodlaw.com. And don't forget, subscribe, maybe share this episode with someone who you think might find it helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.